Court, all rise, please. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Okay. Good morning. After I introduce the panel, I'm going to dispense with my usual preliminaries because I see two experienced people before us, and you know all of our rules. So to my right is Justice Amy Blake. To my left is Justice Robert Toone. My name is Ariane Vuono. We have one case on for today. It is partially impounded. The name of the case is Commonwealth versus Jason Johnson, 2022-1207. Counselor?
Good morning. May I proceed?
Yes, please do.
Good morning, Your Honors. Attorney Rob Espavento for the defendant, Jason Johnson. This case has one issue, in whether or not the statement by the judge in sentencing, where he stated, among other things, quote, "The testimony that I've heard essentially is a rape, and the jury found you guilty of indecent assault and battery." And then the judge sentenced him accordingly. I am stating to Your Honors that the statements that he said this essentially is a rape was improper and used improper factors when sentencing the defendant. For example, Your Honors, at the very least, that statement would be ambiguous if he sentenced him because he viewed it as a rape or an indecent assault and battery.
So do you think the judge was under the misapprehension that he had been convicted of rape?
No. But he did say the testimony that I heard was essentially rape. Obviously, he wasn't.
So can I ask you a hypothetical? Follow me.
Yes.
If I take a wrong turn, I'll try to get back there. But let's assume that somebody stabs somebody and they have really serious injuries, but fortunately, they don't die. Okay. And for whatever reason, the Commonwealth decides to prosecute it in the district court as an ABDW. And at sentencing, the judge says something like, you know, the victim almost died in this case. Sort of like an assault with intent to murder, assault with intent to kill. Is that the same thing that you're arguing here?
I think it's a little different.
Why? Well, let me change the facts. Instead of saying the victim almost died, what if the judge said the defendant almost killed the victim?
That's a tricky one.
I'm not trying to be difficult.
No.
I'm trying to figure out your argument, sort of what the bounds of it are, how far it goes.
Well, I think when you look at the facts of this case, as with your hypothetical, originally he was charged in the district court with rape, and it was null prost, and it was charged and went to the jury as an indecent assault and battery. Same instance with your hypothetical, if he was charged, let's say mayhem, for example, and it was reduced to assault and battery with a dangerous weapon. And the jury returned a verdict of assault and battery with a dangerous weapon. And the judge said, well, sir, I've heard the arguments. You almost killed somebody. I'm sentencing you to 2.5 years in the House of Corrections. I think it's a little bit different, but it's just very ambiguous what the judge said. Is he punishing him and sentencing him for rape, or is he sentencing him for indecent assault and battery?
Well, what about the fact that the judge, actually the sentence itself, which fell in between what the Commonwealth recommended and what the defense attorney recommended?
Correct. The judge could have sentenced him to the maximum sentence of 2.5 years in the House of Corrections. And why it's different is the Commonwealth asked for 2 years with a balance suspended, and the defendant asked for 6 months. I don't think it makes a difference if the judge sentenced him to straight probation or 2.5 years to the House of Corrections. One of the big factors the defendant asked for was obviously a lower jail sentence, but also not to register, which I would argue is probably the most harsh condition you could put on somebody for that. And
I guess my point is, or my question rather, is more directed towards the fact that if we're concerned that the judge sentenced the defendant for uncharged conduct, right? That's your point, that, look, we don't know. It sounds like as if he really upped the sentence because he was punishing him for a rape for which he was not convicted,
Correct.
Right? So if the judge actually does not adopt the Commonwealth's position, a recommendation rather, on sentencing, and is equally close or about in the middle between what the defense counsel has recommended, doesn't our cases say that that's a factor to consider whether or not he's been charged or punished for, is a better word, punished for uncharged conduct?
I'm sorry,
Well, in other words, where do we see the punishment? If the judge had said something like, I'm giving you the max, another hypothetical here, I'm giving you the max because what I heard, the testimony I just heard, that was a rape. I don't know why the DA didn't bring it as a rape, but the DA that's a different branch, didn't happen, so I'm giving you the max. Well, that would be, I think, hypothetically fairly problematic, right? But in this case, although the judge mentioned and explained the procedure of what had happened back, that it had been initially charged as a rape, that rape had been no prost, et cetera, then the sentence itself is not the max, is right in between the two. Isn't that a factor for us to consider?
yes.
Okay.
Yes. He could have given him the maximum sentence, yes, and he chose not to give him the maximum sentence. Well, he gave him the max suspended sentence with the balance suspended for 5 years.
For 5 years, yeah.
Correct. And he did go over the defendant's recommendation, which the judge does have discretion to do that. I understand he could have given him straight probation or up to 2.5 years in jail. I understand that. If I may, I think this case is pretty close to COMMONWEALTH v. Henriquez, 440 Mass. 10/15/2003, where the judges there stated, at the very least, the judge's comments at sentencing were ambiguous as to the uncharged conduct was used for a proper as opposed improper factor in sentencing. I think that it gets pretty close to that, and we're not exactly sure what the judge actually sentenced for, if that was in the back of his mind, or if he says like, this was a rape, why didn't the Commonwealth prosecute that? We don't know. It could have been maybe the Commonwealth thought their case wasn't as strong as they thought. I don't know, but
Do you think that the statement was inaccurate in the sense that, would you agree that the victim's testimony, that the judge's comment was supported by the victim's testimony?
yes. If that went to a Superior Court jury, they could have sentenced him, found him guilty of that, but they could also charge it as a rape in Superior Court, and the jury could find guilty of a lesser included as well. But I think this is because there's so much ambiguity in what the judge stated in that. I understand he didn't say, as you kind of alluded, was, no, I'm sickened of this. You sexually assaulted this woman. You raped her. I'm sentencing you to 2.5 because of that. I don't care what the jury said. Obviously, he didn't say anything drastic like that. But I think there's so much ambiguity here that it was an improper factor. And the Commonwealth states in their brief that it was not an illegal sentence because the judge gave him a sentence within the 2.5 years. I'm not arguing that it wasn't an illegal sentence in that sense. I'm just arguing it's an illegal sentence in that he used improper factors in weighing in what to give this gentleman, Mr. Johnson.
If we were to remand for resentencing, could the judge increase the sentence?
I would argue no. I know so if he gets resentenced and I think it would be unjust to increase the sentence. The only thing I can think of to increase the sentence if he went on and committed more crimes and was convicted between now and then, and the judge looked at his board of probation record and said, geez, look at this now.
Well, that would still be post.
Correct. But I don't see how they could increase it. The judge could keep it the same. He could, obviously can't do very much with the jail sentence because he's out on the street now. He's made parole and all that. So he still has some time of his probation left. The judge could reduce the probation. He could consider whether or not to have him register, I believe. But
Or he could just explain what is his reasoning.
I'm sorry.
Another option would be the judge could simply explain the sentence and be clear about why this particular sentence was imposed.
I think the only way that would work, Your Honor, is if it was remanded to the district court and given to the same judge, because obviously I don't think a different judge could say why this judge did it that way.
Judge Harrington could explicate why he sentenced your client in the way he sentenced him.
I don't see why he couldn't.
Could impose
Yes.
the exact same sentence and say, this is why I ordered the sentence I ordered.
I can't think of any case law that says he couldn't do that.
I mean, he's not, I didn't check. I mean, it would definitely go back to the same judge unless the person's retired or for some reason. I
think you asked us for the alternative relief of remanding it to a different judge, right?
Yes, I've noticed a lot of the case law suggests that that is an option. I think that there would be.
But usually there's some evidence of bias or a reason not to send it back to the judge. Do you think the record establishes that here? For what you characterize as sort of an ambiguous statement.
I don't
Does
think.
that really meet any threshold that would require?
I don't think the trial judge was. I guess some of the cases that I suggested in my brief, they didn't reach that threshold where the judge was just overburdened with making statements to the defendant or the defendant's attorney. I think if you ordered it back to be remanded, be either an explanation why that, or to be resentenced in the alternative, the only other recommendation I would consider is maybe almost like a revise and revoke issue where he could consider what has happened and explain why he made that comment. Was it an off-the-cuff thing? Was it, these are the facts that I heard. They did support a rape, but you were convicted and charged with an indecent assault and battery. I think
we have a tremendous amount of jurisprudence that talks about judges are presumed to know the law and properly instruct themselves on the law. So why can't we just consider this an errant comment and in view of the entirety of the record, including, as Justice Vuono pointed out, that he's sentenced in the mid-range. If we presume he knows the law, he knows he's sentenced him for indecent A and B. I'm sure he would like to take back the statement because then there's no appeal, but why isn't it just an errant comment?
I think just because of, it leaves too much to the imagination, I guess. I'm sure if you ask him, if you go take that way back machine and say, no, I wish I didn't say that, he said it.
He did say it, but he also said it on the heels of hearing a victim witness impact statement, right? The victim testified about the impact of this on her life. That's something that the judge could properly consider.
Correct.
Right?
I think my biggest argument, I think my best argument, is that it's because of the ambiguity of his statement that it should at least, at a minimum, be remanded to have the judge explain why he made that comment. If you're not satisfied with it being remanded in front of a new judge to be resentenced. And lastly, I would say the reason, and I also asked for a new trial. I know the case law is not very good on my side, but I did ask that, one, because I know if I don't ask for it, I waive it, and B, he's already served his jail sentence. He's never going to get that back. He served 18 months in jail.
He's on probation now.
He's on probation.
And he's had to register.
And he's had to register, yes. And I know his probation ends in a little bit, in a couple of years. But unless there are any other questions from the panel, I rest on my brief, Your Honors.
I'll just check with the panel. No further questions. Thank you very much for your argument.
Thank you.
Good morning, Your Honors. Stacey Gothier for the Commonwealth. It's the Commonwealth's position, excuse me, that the judge properly sentenced the defendant for the crime of which he was convicted. We're all aware that a judge has considerable latitude within the framework of the specific statute to fashion an individualized sentence. And one of the factors that the judge can consider is the nature of the offense as well as the surrounding circumstances in the commission of the crime. And so here I would suggest that that's all that the judge was doing when he
You
had
would
stated.
agree, better left unsaid, right?
It was unfortunate phrasing, yes. I would agree with that. But I would suggest that he was just permissibly commenting on the seriousness of the facts of what the victim had testified to, which was it was an extended touching on the skin in her vaginal area. So it's unlike a case where there's like a brief touch on the buttocks over clothes. You know, this was an extended, she testified that it occurred for about 5 minutes until the aunt walked back in and the defendant left the room. It was about 5 minutes, and it was, skin-on-skin contact in her vaginal area, which I would suggest is serious. So I would suggest that he was certainly, it was certainly proper for him to sentence the defendant based on the seriousness of the facts. I'd also point out that there was no objection to the judge's statements at the time, so review would be whether there was substantial risk of a miscarriage of justice.
What's your best case? Is there anything that is similar to this?
So I didn't find anything that was like super similar to this, but Commonwealth versus, I think it's pronounced Holness, Holness. I had cited that in my brief,
Right.
Which is the case that states that the judge can consider the nature of the offense and the circumstances. But in that case, it doesn't specifically say what the judge said, but it does say that the court says that the judge's comments during sentencing show that she considered the nature of the offenses and circumstances surrounding the defendant's crime when she had commented on the fact that there had been a murder, but the defendant had been found not guilty of the murder. So I would suggest, so she had made reference to another crime of which the defendant hadn't been convicted, and she had commented on that. So I would suggest that would be the Commonwealth's best case, although
Does it make a difference that the DA's office initially charged a rape offense and then didn't, because, I mean, the judge clearly made reference to the DA elected not to pursue this charge and then said, what I found, what the facts establish essentially a rape. Does that make it change our analysis in any sense that the judge is commenting on an untried charge that was initially considered by the DA's office?
I mean, certainly it would have been better had he not talked about that crime, but I would imagine, I think during sentencing it was said by the parties that the defendant didn't have a very serious record, so I would suggest, I mean, he seems like maybe he was getting a break by keeping it in the district court as opposed to indicting it. And then with regard to the remand, certainly if the court finds that the judge's comments during sentencing were improper, it could be remanded. I would suggest that there was no ambiguity in the sentence in that it could go, it could go back to the trial judge with maybe a statement asking him to, clarify why he was sentencing the defendant. Certainly, if I know that it can be remanded to a different judge if there's, an appearance of injustice, and I would suggest that that wasn't the case here. It wasn't a case of Commonwealth versus Mills in the defendant's brief where the judge was like discussing his religious beliefs. Enriquez, in that case, the judge said she was going to deviate from the sentencing guidelines because she believed that more incidents occurred than what the defendant was charged with. Suarez, the judge said I'm going to sentence you, within the guidelines of a rape, in case the rape happened, or, because it had almost been completed, or he didn't make any kind of offensive remarks like that. So I would suggest, if you do find it was ambiguous or inappropriate, that it could go back to that judge to clarify his decision.
Okay.
And if there's no further questions, I'll rest on my
I
brief.
don't think so, but I'll check with the panel. No, none. Thank you both very much.
Thank you.
We'll take the case under advisement.
All rise, please.